The law was not yet finished. A story retold with adaptations from a canonical version, which was itself assuredly retold with adaptations from earlier versions no longer remembered. The law was not yet finished. For 39 days, Moses, our teacher, had stood on Sinai in the divine presence as God wrote upon the scroll of the law. With black fire on a white background, the hand of God inscribed its account. The creation of the world, the flood, the covenant with Abraham, slavery in Egypt, exodus into freedom, 10 great commandments, and hundreds of other rules and principles for lives of justice and holiness. After 39 days, God reached the end of the scroll. Now, Moses thought, it would be time to go back down the mountain, down to the people waiting below. But God did not dismiss Moses. God kept writing. Moses was perplexed. He wanted to go back down the mountain. He had been away from the people for a long time, and he was worried about what might be going on down there without him. So Moses spoke up. "Master of the universe," he called, "for 39 days I have stood here as you have written the law. But now you have reached the end of the scroll. Why do you not give me the scroll and send me down the mountain?" "One more day," God answered. "The law is not yet finished." "Master of the universe," Moses asked, "what remains?" "See for yourself," God replied, and went on writing. Moses looked at the scroll, and he saw God's black fire back at the beginning of the scroll, working its way forward again. Here and there, it stopped at a letter. And on the top of each letter where the black fire stopped, God drew a picture like a crown. Moses was perplexed. "Master of the universe," he cried out, "the people are waiting for the law. For this, for these crowns, do we tarry?" "Yes," God replied, "the law is not yet finished." "Master of the universe," Moses asked, almost plaintively, "what can these crowns have to do with the law?" "One day," God replied calmly, "there will come a man called Akiva, the son of Joseph. He will learn the law even from these crowns." Moses was perplexed, but also intrigued. "Master of the universe," he said, "show me." And God replied, "Look behind you and see for yourself." Moses turned around. He saw a vision of a time in the future. In the vision, Moses stood at the back of a classroom behind 8 rows of students. In the front stood Akiva, the son of Joseph, with an open scroll of the law, teaching. And as Moses watched in amazement, Akiva taught the law even from the crowns. "See here," Akiva said to his students. "See that there is a crown on this letter, but not on that letter. From this we know that the law is this and not that. See here. In these places there is no crown on the letter, even though there is a crown elsewhere. From this we know that the law is that way and not this." Moses was perplexed, even disturbed. For of what Akiva said about the law, Moses could understand nothing. Then one of Akiva's students raised a hand and asked a question. "Master Akiva," the student asked, "these things you say about the meaning of the crowns, how do you know that they are so?" And Akiva replied, "This is the law. as Moses, our teacher, learned it on Sinai, and as it has come down to us from generation to generation until this very day. Moses heard Akiva's words, and Moses, our teacher, was calmed. The story I have just told is an old story. Akiva, the son of Joseph, is a historical figure. He was an influential rabbi who lived in Judea under the Romans during what we know as the 1st and 2nd centuries. Nobody knows who first told this story about Moses and Akiva, but it was told and retold, probably a little bit differently by each teller, until about 1,500 years ago, it was written down in the form that has been canonical ever since. Why did the rabbis tell this story about Akiva? As a way of addressing a central worry about the practice of interpreting a great and sacred legal document. A legal document that embodies a community's deepest values, its highest aspirations, its sense of itself as a community, but also a document that is old enough that the way we read it today might not be the same as the way it was read a long time ago. Indeed, the way we read it today might be radically different from the way it was originally read. In the story, Moses does not disagree with Akiva's interpretation of the law. He cannot understand it at all. The concern is that if our reading of the document is different from the original reading, then our reading is not really the law. It lacks both authority and authenticity. It is either an error or a fraud. It betrays the law rather than keeping faith with it. The story of Moses and Akiva argues otherwise. Keeping faith with the law, it argues, is not always a matter of reproducing the founding lawgiver's understanding. Sometimes it is a matter of the attitude one takes toward one's predecessors, even as one reads differently from them. The rabbis who told the story knew that they read the law differently from the way it was read a long time before them. They also knew that when we read the great and sacred law differently from the way it was read a long time ago, we have a choice. We can read with an attitude that repudiates our predecessors, one that declares them benighted or, more charitably, just outmoded, an attitude that celebrates our separateness from what came before. Or we can read with an attitude of loyalty, of fidelity, an attitude that says that we are part of a tradition, that we value our relationship with our predecessors even though our lives and our readings are different from theirs. We want to bring them along with us. As I read the Akiva story, the critical moment comes not when Akiva reads the crowns, but when Moses is calmed. And what calms Moses is Akiva's invoking the name of Moses and the tradition that links them as the source of the authority for the reading. This is the meaning of the law, Akiva says, because this is the meaning of the law as Moses knew it. Moses knows that Moses knew no such thing. But he appreciates Akiva's gesture. He appreciates that Akiva offers his interpretation in a spirit of respectful continuity. Akiva gives the law of Moses a meaning that Moses himself could not imagine. But Akiva does not propose to leave Moses behind. And knowing that he is welcome, Moses is happy to come along. The story is a fable. A fable told in support of the idea that we can read the great and sacred law faithfully in a way that satisfies both the founder and the greater sovereign power that lies beyond the founder, even when we interpret the law in ways that the founder could not foresee. But beware. The story does not mean that interpreters can read the great and sacred law any way they like. Reading the great and sacred law innovatively can be dangerous business, even when the interpreters believe themselves to be reading loyalty. As the canonical version of the story reminded its readers, Akiva ultimately met a horrible death, executed by the Romans as an insurrectionary, which he was. At some point, every self-aware American constitutional interpreter has to address the problem that motivated the telling of the story about Moses and Akiva. We are aware that we might read the great and sacred law differently from the way the founding generation read it. The thought makes us anxious, and we need a way to respond. To understand how we should respond, though, we need to understand why the thought makes us anxious. What is the problem if we read differently? One answer sounds in democracy. The Constitution is the law, this answer says, because it was agreed to democratically by we the people. Respecting the Constitution, therefore, must mean respecting what we the people understood themselves, ourselves, to be agreeing to, until and unless we amend the Constitution by democratic means. There is much to like about that idea, but the idea also has some serious problems. For one, there's the problem of the dead hand. The force of democratic authority is that the people who are bound by the law are the same as the people who make the law. Precisely because the Constitution has been successful enough to persist for a long time, it no longer has the prerequisites for that kind of authority. Almost all of the Constitution, including the amendments, was adopted before anyone alive today could participate in the process. Nor does it make sense to say that the original meaning of the Constitution remains authoritative over time because we the people today choose to treat the Constitution as the law without amending it further. It is true that we continue to treat the Constitution as the law, indeed, as the great and sacred law. That we today consider the Constitution valid and binding is an enormously important part of what makes the constitutional regime legitimate. But our decision to treat the Constitution as valid law does not indicate that we are agreeing or even willing to be governed by the Constitution as it was interpreted hundreds of years ago. It can indicate, at most, that we are willing to be governed by the Constitution as it is interpreted now. The idea that our willingness to treat the Constitution as law confers democratic legitimacy on the Constitution, even though we never affirmatively chose this Constitution, is an idea about implied consent. We implicitly consent to the authority of the constitutional regime by living under it, right? By remaining in the United States and treating its laws as valid, rather than trying to overthrow the government. But the legal regime to which we implicitly consent, right, the legal regime whose laws we treat as valid, is the legal regime that actually exists in our time, not some hypothetical legal regime that might exist if the American government functioned according to the ideas of Americans now long dead. One can only consent implicitly to something that is presently on offer. And the Constitution on offer today has content that the Constitution did not have when it was originally written. The Constitution on offer today prohibits racial segregation, protects same-sex marriage, and requires that elections respect the principle of one person, one vote. All of that would have been surprising to most ratifiers of the 14th Amendment. The Constitution on offer today authorizes the individual mandate rules of the Affordable Care Act and prohibits both Congress and state governments from banning handguns. If we today consent to being governed by the Constitution, then that is the Constitution to which we are consenting, because that is the one we are being offered. To be sure, the Constitution that we are willing to be governed by also contains a set of practices for changing the Constitution. We can agree, and we can argue, and we can perhaps amend. Our willingness to respect the Constitution as it stands is not an agreement to take the Constitution lying down. But neither can it be consent to be governed by the Constitution implemented in a radically different way from the way that judges and other government officials implement it now. Indeed, if we consent to be governed by the Constitution as it stands, by the small c Constitution, by what we actually do around here, we are implicitly repudiating the idea that the only authoritative rules of constitutional law are those that the Constitution's drafters described in their document. And yet, it makes us anxious to think that our readings of the Constitution differ from the Constitution's original meanings. Why? Another answer, perhaps a more realistic one, does not begin from the premise that the authority to govern lies somewhere far in the past. It begins from the recognition that in practice, the past is never a society's real governing authority. We talk about original meanings, and then we point out that it would be anti-democratic and probably also unwise to let society be ruled by the decisions of men long dead. But here's the thing. No country is ruled by dead men, nor by the words of dead men. Countries are ruled by live men, and to a lesser extent, by live women, who sometimes speak of dead men as a way of justifying their rule. The pressing problem is not how to avoid being ruled by the dead hand of the past. It is how to avoid misrule at the hands of the living. One solution the constitutional theorists sometimes offer is this one: constrain the living officials by requiring them to operate within the rules laid down when the Constitution was originally adopted. So perhaps our sense that we should look to original meanings, like our sense that we should look to the text itself, stems from a fear that the alternative is licentious interpretation. Anything goes. Unless they are tethered to the text as originally interpreted, judges and other officials will simply do as they please and call it the Constitution. This answer has problems too. For one, it's hard to find evidence in our constitutional history for the proposition that attention to original meanings prevents judges or other people from reading the Constitution in a wide variety of different ways. When judges disagree about what the Constitution means, they tend also to disagree about what it originally meant. When we, the people, change our minds about race discrimination, the framers of the 14th Amendment seem to change their minds too. John Bingham, the principal architect of the 14th Amendment, might be confused to learn that the original meaning of that provision prohibits most discrimination on the basis of sex. As confused, perhaps, as Moses was sitting in the back of Akiva's classroom. I am guessing that Bingham will get used to it, just as Moses did. It is tempting, perhaps, to say that the variability of original meanings, as I am describing it, just means that up until now, many people have done originalism badly. If we were to do it better, the thought would run, maybe we'd get the real constraint we seek. I suspect that that thought refuses to learn the lessons of experience. We have seen how the process works for a long time, long enough to have a sense of its nature. But I am not saying that American judges are either knaves or fools. That is, that they are either cynically manipulating the original meaning or else making stupid mistakes. The reason why original meanings do not in practice constrain is somewhat different. Human decision makers are not very good at enforcing the commitments of a prior time once those commitments have ceased to seem natural or persuasive to the decision makers. Some will try, but it is just plain hard to understand the past on its own terms, rather than as a projection of the present. Judges and senators and presidents are not selected for having the skills or the habits of mind that make that enterprise more likely to succeed. there is a natural tendency to construe a prior heroic generation's commitments as similar to one's own, until the point where one's prior historical knowledge will not permit the dissonance. And decision makers often have little historical knowledge concretely on point until the need to make a decision creates both pressure and need to read the sources in the way that the decision maker hopes they can be read. Under the pressure to make important decisions and to make them well, decision makers are likely to construe ambiguities to permit or require decisions that strike them as sensible, rather than decisions that strike them as less sensible. For these reasons, and others, even officials who in good faith wish to be bound by the commitments of the past are likely to fail in the attempt. So what then is the real problem, if there is one, with leaving the founders behind? I am tempted to say that there is no problem. We have better information about our problems and the potential solutions than the founders possibly could have had. We constrain our judges better by holding them to the rules of common law precedent than by setting them loose in the historical archives. And to the extent that our values differ from those of the founders, it seems to me that ours and not theirs should govern. We the people are we the people now. Jefferson wrote that the earth belongs to the living, and that no generation has the right to impose its rules on generations that come later. I think he was right. But as you have all recognized, my impulse to cite Jefferson, even when negating the authority of the founding generation, suggests that something about our relationship to that generation is hardwired into American constitutional culture. We can and we must understand the problems with thinking that original meanings must be treated as authoritative. But it seems like a form of folly to expect that we will stop invoking the founders in our constitutional arguments. An attempt to get us to stop invoking the founders when reasoning about constitutional law would itself be a failure to learn from experience, just as surely as it would fail to learn from experience to think that we will start invoking them with historical accuracy. And if we pay attention to the part of our experience that indicates that invoking the founders is a part of our system, we may also realize a way in which our relationship to the founders does constrain constitutional interpretation. We are not in practice constrained by what the founders actually thought, but we may be constrained by what it is possible for our decision-making class at any given time to believe about what the founders thought. The American decision-making class is a community that includes you. It includes you more and more week by week. That class at any given time projects its values onto the founders. But we do not simply reimagine the founders any way we please, from one day to the next. Nor does any lawyer or any court single-handedly bring about the change. Change in our intuitions about the founders happens over time, usually slowly, as more and more of us gradually become persuaded, in good faith, and often without realizing it, to understand them, or some aspect of them, in a new way. No constitutional lawyer would have gotten very far by arguing in the year 1900 that the framers of the 14th Amendment intended to authorize courts to order the desegregation of public schools, or even that the framers' views on the matter were inconclusive. No constitutional lawyer would have gotten very far by arguing in 1960 that the original meaning of the Second Amendment protected an individual right to own firearms for personal self-defense. And what we believe about the founders today is usually a pretty good guide to what we will or can believe about the founders tomorrow. But it's harder to predict today what it will be possible to believe a generation or two in the future, except in this general respect. You can count on the future to think something different from what you think today, whether it's trying to or not. I recognize that some of you are thinking, actually, I don't project my views onto the founders. I don't think the founding generation was heroic. I think it was deeply flawed, and I am not interested in presenting my ideas about how constitutional law should work as if they were consistent with or a vindication of that generation's ideas. To you I say, I hear you. Of course the founders were flawed. But the enterprise of constitutional interpretation, an enterprise on which a great deal of law that affects a great many people depends, is one about which perhaps you need to grapple with this reality. Either the future will think that the founders believed in things that would make constitutional law more like you would like it to be, or the future will think that the founders believed in things that would make constitutional law more like what your opponents would like it to be. It's up to you to decide which future you would like to help bring about. So now, back to Moses and Akiva. In its canonical form, the Akiva story exhibits Moses as the proof that it's all right for legal interpretations to change over time. If Moses himself is satisfied when Akiva reads innovatively, who are we to argue? But note what the story does not tell us. The story doesn't tell us whether the student who asked Akiva to justify his interpretation of the crowns was satisfied with Akiva's response. Moses was satisfied, yes, but it isn't Moses whom Akiva needs to persuade. He needs to persuade his contemporary audience, his living community. Was the student satisfied? I don't know what point of law Akiva was teaching that day. But whatever it was, for his interpretation to be successful, it would need to do more than play cleverly with the text and the calligraphic crowns. It would need also to be substantively persuasive to his audience as the kind of thing that that text might say. Attributing the interpretation to Moses might help, but only if the student could believe that Moses might have thought such a thing. And I presume that the student thought that Moses, in general, thought wise things and just things and things that made sense. Something similar is true for constitutional interpretation. A successful interpretation must do more than make the rules of constitutional law accord with the text of the document we call the Constitution. Indeed, sometimes it need not make sense of that text at all. But it must make the rules of constitutional law make sense in light of the common sense and normative commitments of the audience, an audience composed of judges and other officials and lawyers and citizens. It helps if the interpretation seems easy to reconcile with the constitutional text. And it helps if the interpretation seems easy to reconcile with things we know or think we know about the founders. Those things help because part of our values and part of our common sense is a set of ideas about the importance of the text and of the founders and of the national constitutional story. We understand ourselves as a people governed by a constitutional text. And we understand ourselves as people who are faithful to the vision of a heroic founding generation. I am not saying that every one of us understands ourselves that way. Nor am I saying that those of us who do understand ourselves that way feel an obligation to agree with everything the founders thought. That would in any case be impossible, because the founders were many people thinking many different things. The point, rather, is that a general sense of connection to the written Constitution and to the story of the society that produced it is part of the American constitutional ethos. And that, ultimately, is why a successful interpretation must make sense of the text and of the founders and of the story. Because if an interpretation seems at war with the text or the founders or the story, we will find it that much harder to recognize that interpretation as part of our ethos. But to the question, how well must an interpretation make sense of the text or of the founders or of the story? The answer can only be this: well enough to create the sense in the audience that the interpretation is authentically part of our constitutional ethos. Because the final criterion for deciding whether a constitutional interpretation is successful lies neither in the text nor in the past. It lies in us. But it does not lie in us individually. It lies in us collectively as a community of constitutional interpreters. And we do not always agree. What seems a compelling interpretation to you might not seem like that at all to me. So if the meaning of the Constitution is ultimately a matter of what makes sense to us, rather than something residing objectively in the text, there might never be one clear consensus meaning of the Constitution. There might be only a long-running argument about what the Constitution means. Put another way, the law might never be finished. Some theorists look upon this possibility with concern. The Constitution is supposed to bring order, and the Constitution is supposed to bind us together as a people. How can it do that if we cannot even agree on what it means? I am not so worried about this problem. For one thing, we actually agree on a good deal. We do not argue about how many houses of Congress there are. We have not argued yet about whether a president can serve more than 2 full terms, though it's foreseeable that one day we might. We do argue about whether it makes any sense for Texas to have the same number of senators as Wyoming, but we do not argue about how many senators each state is entitled to today. We do not argue about whether states can tax white people's income at 10% and non-white people's income at 20%. Nor do we argue about whether the federal government could engage in such discriminatory taxation, or whether the First Amendment runs against the president. Some of these rules are textual, and some of them aren't. But they are all firmly constitutional rules, and they are all common ground. In other areas, we disagree. We disagree about guns and abortion and executive power. But I want to suggest that this disagreement is not only a problem in constitutional interpretation, it is also a solution. One of the Constitution's most important functions is to bind us together as a people. For it to do that, we must each be able to claim it, to recognize it as an embodiment of our deepest values and highest aspirations. And again, we differ in our values and our aspirations, and we always will. So if we are all going to value the Constitution, if the Constitution as a symbol is going to bind us together, then we are going to need to be able to interpret its meaning differently from one another. If it had to mean only one thing, it couldn't belong to all of us. Here again, we can learn about the Constitution by comparing it to that other great and sacred text. Billions of people revere the Bible, but they do not read it all the same way. If they had to read it the same way, they could not all revere it as they do. So here's the hard trick. The hard trick is to be able to have different interpretations of the great and sacred law without letting those interpretations become a cause for further division and distrust, even though they are different from one another. To be able to recognize that someone else's interpretation might be different, and even from your point of view, not as good as your interpretation, or even that it might be wrong, without thinking of the other person as a heretic. As Justice Holmes put the point, the Constitution is made for people of fundamentally differing views. You should have a reading of the Constitution. and you should have a principled way of arriving at your reading of the Constitution. But if you can remember that your reading of the Constitution is not just a reading of the text itself, that it is informed by many things outside the text, then you might be more tolerant of someone else who understands the Constitution differently. Because your reading is not demanded by the text itself, nor by the text as read by the founders. Your reading is perhaps a good reading of the text in light of a tradition and a structure of government and a national ethos and the demands of liberty and justice as you understand them. But several of those things have considerable indeterminacy, such that more than one reading must be possible. Let me be clear. The existence and even the desirability of multiple interpretations of the Constitution does not mean that the law on any point can be several different things on any given day. It cannot. People need to know over many domains of their lives what they can and cannot do. We cannot permit a multiplicity of interpretations to authorize judges and other officials to do whatever accords with their own favored views. We need law in part because we need officials to be constrained. We need to know what officials will and will not, may and may not do. We cannot permit the people who exercise governmental power to do whatever they please. And therefore, those people must understand themselves to be constrained by law. You, as lawyers, will know many important things about the constraining force of law. You will know it by knowing doctrine. Knowing doctrine is extremely important. It is a basic requirement for your professional competence. Moreover, you should beware of thinking that your view of the best possible interpretation of the Constitution can be entirely independent of judicial doctrine, and that's for two reasons. First, judicial doctrine is one of the forces shaping the system over time. It shapes the structure and the history. It shapes the things that a good interpretation must account for. And eventually, it also shapes the ethos. We usually associate the idea of a bully pulpit with the president. But the Supreme Court also has a bully pulpit. The court is, among other things, a great technology for shaping the intuitions of the audience and of the next generation about what the Constitution could plausibly mean. Nonetheless, knowing and respecting doctrine is compatible with recognizing multiple possible interpretations. I know that the Constitution can be interpreted this way, and I know that the Constitution can be interpreted that way, and I know which of those ways is the law. Which way is the law today, for now, for the intermediate term, the term in which my client needs my advice? But the fact that that interpretation is the law at the moment doesn't mean that it is the only reasonable way to interpret the Constitution, or even necessarily the best way, in any sense other than its being the way that a certain set of officials endorses at a particular time. This doesn't mean that every reading is potentially a legitimate good faith reading. That there is no one single truth does not mean that there are no falsehoods. Sometimes the other interpreter really is just dense or even mendacious. In the year 2025, we should be keenly aware of the danger that comes when officials and the people who support them are willing to say anything at all, unconstrained by truth or reality, in pursuit of their agendas. If too many people are willing to pursue their ends in government that way, then law becomes merely a test of power. If too many people are willing to break the system to get what they want, no matter what the rules are, no constitutional system can survive, no matter what principles are offered for constitutional interpretation. That danger is a present reality. But I propose to meet and fight that danger in the name of the Constitution, not by setting myself apart from the Constitution. Success in that fight will require each of us to join with people with whom we disagree deeply about many important things and assert that our shared commitment to a flawed but still precious Constitution, not just big C, but small c, is, at the moment, more important than those disagreements. If we can protect the system in its moment of acute danger, perhaps we can then go on, each of us, to try to persuade other Americans to understand those constitutions in the ways that we each think would make them most worth having. That acute need for alliance across difference reminds us that even as we must be vigilant against behavior that would wreck the system, we must distinguish between ideas that are incompatible with the survival of a constitutional system and ideas with which we disagree, but which can be held in good faith by people committed to the basic requirements of a constitutional system. If I can remember that my interpretation of the Constitution is not demanded by the text and nothing but the text, or by the text and the one true meaning that the founders breathed into the text, I should be tolerant of many other people whose interpretations differ from mine. Not of everyone, but of many. So here is one last thing that the Akiva story leaves out. Did Akiva know that his reading of the text, taking the crowns to mean something consequential for the law, was not the only way to read the text? Did he offer his reading as one interpretation, in his view, the best interpretation, all things considered? Or did he insist that he had cracked the true code, that his interpretation was the only correct one? Was his invocation of Moses meant to show respect to a tradition within which he knew himself to be innovating? Or was it meant to say that any other interpretation was false to the one true law? The final challenge, then, is not about whether we can find a method that will persuade everyone to accept the same interpretation of the one true law. It is about whether we can continue a conversation in which people with different intuitions about constitutional law can respect each other's ideas and value remaining in community with one another enough to let them operate a constitutional system that is reasonably acceptable in practice to a broad and disagreeing community of interpreters. Whether we can do that is partly a function of the cogency, good faith, and self-awareness of our claims about interpretation. But it is also deeply a matter of the degree to which we share or can accept each other's intuitions about substance. The more we agree with each other about the requirements of justice and liberty and democracy, the more tolerant we are likely to be of each other's quirks about interpretive theory. The less we agree about those substantive things, the more work law will have to do to hold us together. And the law is not magic. It is multiple and not yet finished. It has been my great privilege in the semester now ending to have learned with you and from you. The semester now ending had 13 weeks. If a class meets 3 times a week for 13 weeks, it ends on the 39th day. So the course is over, but the law is never finished. And I thank you for your attention.